good, thanks.
Super. Well, good morning. Thank you so much, Marianne, for joining us. And for those listening, this is one of our recorded HR reflection sessions that we're hosting across Gravitate HR. I'm delighted today to be joined by Marianne McJannett, partner of Aberdein Considine. And Marianne has been supporting us for a very long time at Gravitate HR, supporting our clients through some complex cases, HR matters, and specifically employment law matters. So it's my pleasure to have Marianne with us today. Out with HR, Marianne and I like a few things in similar interests, such as being outdoors, some yoga sessions, and the odd wild swim across Scotland when we get the benefit of doing so in Scottish weather. Today, we're going to be looking at key developments with Employment Rights Bill, what's happening just now in 2025, but more so what to expect in the coming years as we approach autumn 2027. And so we'll focus on that aspect in itself and maybe some more things to think about this year.
And again, I think it's having an understanding of what your contracts say just now. Yeah. So understanding what that says, what that means for your staff and what that means for your business, and how you might need to, how could you pull back from that if you needed to?
Yeah, and I think it's looking at what's implied in practice as well. And
absolutely,
although there may be explicit terms in the contract, how are your staff working in that contract? Is there slight variations that may be challenged because they've been implied for a longer time as well? So I think that's a bit of a grey area for what we might see when we work with some HR managers on the reality to a contract in practice over what's written in terms and conditions, but then how it's utilised in communications and consultation as well.
Absolutely. And so the thing with this, and for all of it, and you know, I say this, and I will say this forevermore, and I've said it for years in practice, is having an understanding of the policies and the documents that you've bound yourself to. They're legal documents. An employment contract is a legal document between an employer and an employee. So having an understanding of how that binds you as an employer and what rights it affords to your employees is crucial, because there's so many times that I in tribunal have either had clients being cross-examined or I'm cross-examining employer clients about their knowledge of policies or procedures, and they don't understand what it means. So I think kind of having almost an audit of where things are just now, identifying kind of potential weaknesses, and making sure that the people who are the decision makers in the organisation have an understanding around what it is they're putting in place and what it means for them as a business.
Yeah, and I think that's something we'll see if we're maybe working with a new client that has unfortunately had to react to an issue that has then led them to saying, actually, what's in our contract, and realising that they maybe haven't looked at their contract in 20 years, that there's a big gap in what is happening in practice, and the terms and conditions are perhaps not fit for use if they are needing to use them later on at litigation or reacting to consultations because what's happening in practice isn't actually the reality in writing. So we'll definitely probably be looking at working with a lot of our clients to review that. If they're not already aware, can we help them do that as well? So if it ever moves over to you or your colleagues' realm, that they are quite confident of what's in writing is what's happening, so it can be used in cross-examination as well.
Yeah, and I think sometimes people are maybe looking at it just now going, was there any point making changes to documents just now when, you know, further changes are coming down the line? And I always think there's an importance of regularly reviewing contracts and policies, but I think just now of having an awareness of what it says and how that applies, you know, so even just having an understanding of, well, who's the person that signs off probationary periods, you know, you know, do your line managers know how to sign off probationary periods? Do they have a checklist that they want to get through? Do they have, you know, the autonomy to extend probationary periods? Does that simply sit with, you know, an HR facility within an organisation, or is that, you know, solely handed over to line managers? Having an understanding about how you deal with flexible working requests just now, you know, and then thinking about, well, actually, as I say, have an understanding of what your contracts say, I think is absolutely the best approach just now. So proactive, not reactive, is always the key.
Yes, which I think might be the key for
For this.
today's review.